The SEC can create rules that are law, that Congress never sees, the president never sees. So they create rules. They also have the enforcement division. They prosecute violations or alleged violations of those rules. So they are the legislative branch. They're the executive prosecuting branch. And then, as you found out with your dad,
the judicial branch.
An SEC employee is the judge. I mean, so they are literally the judge, the jury, the prosecution, the legislative branch. It's all the branches rolled up into one. And that's not fair.
Welcome back to Vaulted Views, where we help financial advisors see higher, think bigger, and grow smarter. I'm Ray Lucia Jr., and I'm coming to you yet again from the vault. And today we're talking about something every advisor in the country should care about. And almost none of them are thinking about until it's actually too late. It's what happens when the SEC decides to point its full power at just one person. And so here's the low view. Most advisors treat the SEC like bad weather. It's something that just exists, that happens to other people, that you hope never lands on you. You keep your head down, you do your checks and balances, and you assume that if you play it straight, the system will treat you fairly. You assume there's a courtroom and a jury and a judge who's neutral. You assume the deck is even. But here's the vaulted view. You understand how this machine actually works before it comes to you. You know that an SEC case doesn't necessarily go in front of a traditional judge. It can go in front of an in-house judge who works for the same agency bringing the charges. That's like the home court advantage. You also are aware that there are gray areas where ordinary people just could get destroyed. And you know that the deck is stacked and exactly who's fighting to unstack it. My guest today, Nick Morgan, he has lived both sides of that machine. Nick has spent 7 years inside the SEC as a senior trial counsel. He was the one actually bringing these cases. And then he spent the next 18 years defending investment advisors and entrepreneurs against the same agency, and most recently as a partner at the global firm Paul Hastings. And then he did something almost no lawyer does. He decided to found a nonprofit. It's called the Investor Choice Advocates Network, ICANN. And he set it up to fight precedent-setting cases for the little guy, and he does it for free. And I'll be straight with all of you today. This one is a little bit personal for me. As you guys have heard in the past, my father, Ray Lucia Senior, he went through one of these ordeals, and it went all the way to the Supreme Court. So Nick and I are going to talk shop right here in the vault, and we're going to talk about how the system really works and what it takes to push back. And so Nick, welcome to Vaulted Views.
Thanks, Ray. Glad to be here.
You know, I know we've been trying to get this on the calendar for a while. You're a very busy attorney. Lots of people to help out there.
A lot going on. Yep.
Yeah, so why don't we just jump into it, right? So you spent 7 years at the SEC.
Right.
And now you're on the other side. You spent the last, 18 years?
Yeah.
On the other side of it all.
Yep.
So tell everybody about that and who you are, your background. Let's just get a good understanding of who Nick Morgan is from ICANN.
Well, so yeah, it's a good place to start. At my time at the SEC, I was in the enforcement division. I was in the trial unit, which is sort of an elite part of the enforcement division, and we were litigating cases.
Okay.
So I was attracted to it. I thought, hey, there are bad guys out there. I'm going to go help catch them, and we're going to prosecute them for securities fraud. So I joined as a pretty young lawyer in the Los Angeles office enforcement division trial unit. And it was great. We spent a lot of time in that office going after Ponzi schemers and going after people who were committing blatant fraud, stealing money from everyday people. It felt like a good thing.
Yeah, the real bad guys.
Yeah. I will say at the end of my tour of duty there, I began to start working on cases where I started questioning, what are we doing here? We were pursuing very sort of technical violations and things where I wasn't really on board with the kinds of cases I was asked to work on toward the end of that.
Okay.
But that's not why I left. I left for the reason that most people leave government
Money, right?
service. Yeah, I needed, I
You want to make some
kids
money.
in school,
Yeah.
their bills are coming due. So it's a pretty well-recognized thing to go to the other side and defend people. So I went to a couple of very large law firms, including most recently Paul Hastings.
Right.
And
global firm.
I was in their investigations and white collar defense group. So kind of a mouthful.
Okay.
Every big firm has a group like this. It's made up of former SEC people, U.S. attorney people. And so we represented defendants against the SEC who were charged with or being investigated for possible violations. And that was good. I was good clients, able to help some people out. The firms charge a lot of money, and clients are willing to pay for it if you get the right help.
Right.
So my partner and I, who founded ICANN, that we get to here in a minute, the nonprofit, we noticed something over time. So I was doing that for 18 years. Not everyone can afford to pay not only big law firm rates, but law firm rates at all in an SEC matter. These SEC matters can go on for years. Even before, I know we're going to get to that in a minute. But even before they file a lawsuit, there's a pre-lawsuit investigation that they conduct. The average investigation goes on for 2.5 years. So imagine paying a lawyer at the exorbitant rates that they charge for 2.5 years before you even get to court.
Before you even get to, yeah.
Yeah. So by the time you get to the starting line, most people are exhausted financially, emotionally. And then,
which is one of the reasons why most settle.
That's right. And then maybe you litigate, and litigation in federal court or in the SEC's administrative courts, that can go on for years. So what we noticed was nothing, we weren't original in making this observation. Most people can't afford to do this fight. And so most people settle, or they try and represent themselves. So maybe that's okay. But the other thing we noticed is that because everybody settles, over time, it's like grains of sand. You get built up this body of law that's pro-SEC. And again, if the SEC kind of stayed doing what its major functions are, maybe that would be okay. Like it would make it easier to go after fraudsters. But that's not all the SEC does. We're going to talk about some people, like ordinary people who didn't steal any money, who are doing technical violations. So what we noticed was that more people needed to fight back for our adversary system of justice to actually create law that's fair. So what ends up happening over time with everyone settling is the deck gets stacked against normal people. Yeah, and we didn't think that was right.
And through my father, I've seen it firsthand, right? So let's dive a little bit deeper into that asymmetry that you've seen, right? And so tell us more about that, right? Because the government has unlimited resources. Right. They know the law. Right. In many cases, if they go through an administrative law judge. Right. They're they have home court advantage in a way. Right. So to the guy on the outside, I'm not talking about the Ponzi schemer. Right. But the average financial advisors are watching this podcast. Yeah. Right. Yeah. What is it that they need to know? What can you say to help them understand what the environment is? Yeah. Should the SEC or FINRA or somebody else come knocking on their door someday? Right.
I think most Americans, let alone people in the financial services industry, assume that there is a fair process out there, and that if they ever get caught up, if the SEC or FINRA ever comes knocking on their door, they can rest assured they don't have to think about it because there's a fair process. I think that's a common belief. The process is not fair. The process is absolutely stacked in the regulator's favor. And that is a result of the process I described before. Whether it's Congress or judges or the SEC itself, they believe that because some parts of their mission going after the crooks is righteous and justified, they stack lots of different procedures and laws in favor of the SEC. So if you're an ordinary person who's not stealing money, who's not committing a financial fraud, you step into that unfair process that precedes you. And so I think that's probably the biggest thing people should be aware of is just because you haven't encountered this unfair process yet, don't assume that it is fair. Because once you get wrapped up in it, it doesn't take long to figure out that it's not fair.
And you're talking about the process once the SEC's kind of already been interested in some activity.
Yes,
right?
That's right.
I would argue that even the rules are somewhat unfair, right? As a practicing financial advisor and running wealth management firms all these years, going back, I used to be a kid. I was probably one of the most highly regulated individuals in the industry.
Yeah.
Running 3 RIA firms, a broker dealer, and a closed-end mutual fund, while I was also the chairman of the board of trustees of that fund.
That's at least 3 different statutes,
all
right?
At the same time.
Right.
While my father is suing the SEC and taking them to the Supreme Court.
Right.
So I've learned so much about this space. I think it's made me a better business owner and financial advisor.
Right.
But the rules, the way they even write the rules, leaves a lot of areas open to be gray. Right. And then they have this kind of concept of form over substance. Right. That they apply. And so I don't want to say that's unfair. I mean, I'm sure there's reasons for different gray areas and stuff, but it leaves room for judgment. Right. And then there's different perspectives and then that ends up resulting in a disagreement that results in a process where then someone's interested in hiring someone like you. Right. So
I agree, by the way, the rules themselves are not fair. And there are loads of examples where people get caught. They're like a trap for the unwary. And you don't know, you think you're complying with the law, and the regulator, the SEC or FINRA, takes a different view. And that's disastrous.
It's disastrous because their view is the only view that matters.
That's right.
Right? According to them.
That's
and
right.
They also are the ones that are going to litigate against you and then, ultimately fine you or bar you or anything.
Right.
And maybe, I think for me, the best advice for a financial advisor is understand the regulatory environment. Right. Understand the rules. Don't be one of those financial advisors that just sit back and say, you know what, my firm, my broker dealer, or my RIA firm is going to take care of that for me. They'll tell me when I'm doing something wrong and they'll correct me. They will. Right. But understand beyond that, like the nature of the system and how it works, and be educated. And so for financial advisors, there's a lot of them. We at Quotient Advisor Community and Quotient Advisor Partners, we tend to speak to go advisors and grow advisors, right? And both of them kind of fit in this what I'm about to say. Go advisors are looking to leave the big firm and to go on their own, right? And one of their choices is to start up their own RIA firm, right? Now, it looks great on paper, right? And the compliance, the third-party compliance, outsourced compliance firms will tell you they have your back, right? The financials work out, but there's a mental tax, right? And an emotional tax that often you don't even add into the equation, which is when you run your own firm, you're directly exposed to the regulators, specifically the SEC. And you could be doing everything right, but maybe it's performance advertising, right? Maybe it's just your social media advertising. Maybe you say something and they have a different perspective on how you said it. Maybe you made something that was overly promissory, right? And that turns into something could be much larger than it actually is.
Right. Can I give an example?
I'd love to hear stories. Tell us stories, Nick.
Well, so this is just from recent history, and most of your audience probably is already aware of it. But there came a time during COVID when registered reps at broker-dealers or individual advisors at advisor firms were communicating with clients. They weren't in the office. They were working from home. So they were communicating with clients via
remotely,
their phone, their personal phone, their texting, their signaling.
Okay.
This came to be known as off-channel communications. Okay. So, broker-dealers, and to a lesser extent and for different reasons, RIAs are required to keep records, maintain them.
Right.
So the entire industry did not view a signal chat between a rep and a client about golfing as a record that needed to be kept. No one thought that. As you say, there's some vagueness, some gray areas in the interpretation. The SEC came in after the fact and said, oh, we think that all of those off-channel communications, in other words, communications not through the firm's communication systems,
Right.
we think those were records that you were required to retain. I'm talking about JP Morgan didn't think this, Credit Suisse didn't think this.
And they have the massive compliance and
Massive
legal
compliance.
departments.
They were
right?
not retaining these. And so the SEC settled, basically sued them and settled with them on the same day. And these firms were paying 6-figure settlements, 7-figure settlements over an issue that no one thought was a violation. There was no evidence that anyone was harmed by it. And the SEC is now taking the same view, or has been taking the same view with regard to off-channel communications for investment advisors, not just broker-dealers. So it's a perfect example of an area where, I mean, I would not want to be paying a personal 6-figure settlement to resolve an issue that nobody thought was improper. So it's tough.
That resonates.
Don't want to hit too close to home, but
there's close to home.
Yeah,
a little bit, not for me, but for my father.
Right.
Yeah, I mean, so like the process typically, and fortunately, and unfortunately, I've lived it. But it starts with an audit, and that audit can go on for months at a time. Every audit results in a deficiency letter, right? I don't know of any RA firm that's ever gotten a clean exit interview.
Very unusual.
I mean, you
Very
can tell
unusual.
me, right? So it's almost like the examination folks need to point out a few things at a minimum so that they can prove that they actually did their job. So a deficiency letter is it's typically no harm, no foul. It's just like, hey, fix this, fix that. You write a response. Here's how we're going to fix this, or here's how we've already resolved these issues.
Right.
And it goes away.
Right.
But if there's an issue in the deficiency letter that rises to a certain level, then it goes another step, right?
Yep.
And this is the 2.5 year pre-work that you're talking about.
Well, what you just described, the exam, is even before the 2.5 years. So yes, exam, and then potential referral to the enforcement division.
Yeah. So it goes through a whole process that results in a Wells notice.
Yep.
Right. Which is basically, don't the examination folks got to go to the commission?
So let me back up a little bit.
I'm really curious.
This is the nightmare is worse than you're describing it. So let me just.
Sorry, guys. I mean, hopefully this is intriguing.
Right. So the exam staff and the enforcement division are two different bodies within the SEC. So the exam staff rolls out periodically or for cause, and they do what you said, it's like an audit. Yes.
OC, and then the Division of Enforcement.
Correct. Right? Two different groups.
Correct.
Okay. So the exam staff is entitled to examine you whether you're doing something wrong or not. This is like a routine thing, or they can do it for cause. And then you're right. The end of that process is usually deficiency letter, some back and forth. But maybe known to you, maybe unbeknownst to you, the exam staff has every incentive to refer it over to the Division of Enforcement. So you could have just spent weeks giving the exam staff a bunch of documents, sitting down and being interviewed by them and giving them information like on a personal level. And then because they want to be seen to be doing their job, they, in many instances, refer it to the enforcement division. Hey, we noticed some deficiencies. Maybe you want to take a look and see whether these rise to the level of something the enforcement division wants to do. So then it starts all over again. So then the enforcement division sends you a subpoena or a voluntary request for records, sometimes the exact same records that you gave the exam staff. And they want to take your personnel and put them in a room and take their deposition. They're called testimonies, right? They're on the record, they're recorded. Generally, you're represented by a lawyer. So like the thing you just went through, you get to do it all over again. At the end of that process, the staff, the enforcement division, if they decide they think there's something there, they have to go get approval from the commissioners to file a lawsuit. Usually that approval happens.
Right, because they're going to present their one-sided.
It's very one-sided. You don't get to be in the room when they make this recommendation. It's behind closed doors. And there is a Wells process you alluded to. So they will ask you for your review. We're about to recommend that the commission sue you. What do you say? So if you want to, you can give them your side of it in a written form.
Yeah, what do they do with that, though? Is that like their hopes of like, okay, they're just going to come to the table and settle?
Sometimes.
Because it's going to move forward regardless of your response.
So they have to tell the commission what you said in your Wells submission.
Okay.
But they get the opportunity to say, yeah, they said this, but, and they get to rebut it. And
without you
seeing how they rebut it. Right.
Mhm.
You don't get to be in the room for that. So most of the time the commission approves a recommendation to file a lawsuit. And then, so you've done exam, you've done enforcement investigation, and now you're in court, or worse, in their administrative court. So and then you're litigating if you choose to litigate. So it's as you know, grueling.
That is a grueling process.
Yes.
And it does seem unfair, especially where you've got the examination folks requesting documents. And it appears, I don't know if this to be true or not, it appears that sometimes they could be requesting documents for the enforcement folks without you knowing that 100%. There's an enforcement process.
100%.
Right? So now so that by the time they sue an advisor, right? They've done all this legwork, they built their file, it's been built over years.
Right.
And then you've got 6 weeks before the hearing?
Yeah.
Right?
Yeah.
So now you're already on the defense.
Yep.
You've got 6 weeks to put your case together.
Yep.
Right? There's back and forth and all that stuff.
Right.
So it is skewed, and not just the rules
Very much so,
are skewed, and not just the after the fact the laws, and we'll call them laws in air quotes, the administrative cases that set precedent for reasons that
become law,
right?
Yep.
But even just the whole process, and so in many cases, they're building a case. You don't even know you're being sent to enforcement.
Right.
They already have their ducks in a row.
Right.
And now you got to figure out how to get your ducks in a row.
That's right. So you just alluded to one way that they can litigate cases, and actually your father played an important role in putting some limits around this, and that is to use their internal in-house SEC courts, their administrative courts. And one of the benefits that the SEC touts for that is that it's super efficient, meaning fast.
Yep.
But efficiency and quickness doesn't help us. As you say, okay, go, let's litigate. Well, wait, I haven't deposed any third parties or customers. I haven't collected any documents. You have years worth of discovery conducted before we even start. So I don't want to get in front of your administrative law judge quickly. I need some time to do this. And so this process is touted as being efficient. Well, yeah, it's efficient for the SEC.
Right.
It's not efficient.
Which also stacks the deck in their favor.
Absolutely.
Yeah. Since you mentioned my dad, just going back in the days, I mean, I wasn't involved in any of his stuff.
Yeah.
Up until until the end, until actually the law judge, issued his order barring him, which I didn't even see coming. And that's when I really got involved. I was a bystander along the way. Yes, I was a witness and all that other stuff along the way. But watching him go through that process in such a short period of time, while trying to manage reputation risk and everything else, and the business, and it's there's other factors that go on for an advisor. And so I guess my whole point is, what was the Mike Tyson's line?
Everyone has a great plan until you meet your opponent's fist, or
until you get punched in the face. Right.
Yeah.
Everyone's got a plan until they get punched in the face.
That's right.
Right. And so if you're just sitting at home and you're watching this, you got a great plan. You're running your wealth management firm. Maybe you're a solo IAR of a registered investment advisor firm, or maybe you left and started your own firm.
Yeah.
Everything's going fine until it's not, until you get punched in the face. And so, my hopes with this interview with you, Nick, is just to give people a little bit of insight into the process, so that maybe you're a little bit more interested into what's going on. Just besides, how do I generate more leads? How do I manage my practice more efficiently? Right? How do I generate more EBITDA or EBOC? That's all fine. Yes, you guys should be focusing on that, but there's this regulatory world that we live in. It's super important. We want customers and investors to be protected from the bad guys.
Right.
But every so often, the good guys get caught up in this mess.
And it's like a dump truck hitting you when you get caught up in this mess. It is a life-changing experience. And most people going about their daily business don't have the time or energy to be worried about whether the process is fair or whether the deck is stacked against them. And even people who get sued, their biggest interest is in putting it behind them. Like, let's settle and move on.
Right.
So as I say, that means that no one's kind of minding the store from the fairness perspective. It's just being minded by the SEC, which is continually building things in its favor. And that's ultimately why we started the nonprofit, because somebody needs to be fighting back.
Yeah, I was gonna segue into that. Right?
Yeah.
So tell us more about ICANN.
Yeah.
Right? So what is ICANN? Hit a little bit more deeper on why you started it. It's
Right.
super important. Coming from a guy who was on the inside, then on the outside, and now a nonprofit.
Right. So ICANN is Investor Choice Advocates Network. So I believe that all of what we've just been discussing, the unfairness of the process, ultimately harms investors. And that's who the regulators are ultimately trying to protect.
Right.
And I think that if you gum up the works with lots of unfair processes, I think ultimately it does not help investors.
Agreed.
So that's why we called it that. We're a 501c3. We survive on charitable donations. We provide legal services for free. And so, but not just to everyone.
Yeah, I was gonna say, how do you decide which cases you take?
Yeah.
Hey, I'll take a free attorney any day of the week. Right.
Yeah, we've had a few phone calls.
Can you look at this contract I'm going to do?
Right.
Nick,
I'm running this Ponzi scheme. Can you? Yeah. No. So we have to be very selective, and so we take cases where our client is not accused of fraud, not accused of stealing anyone's money, and they can't afford counsel. Obviously, if they can afford counsel, there are lots of great lawyers out there.
Sure.
They should go hire them. And then the most important thing is, if they satisfy all those criteria, is the thing that they're fighting about a precedential issue that everyone will benefit from.
Right. So you're trying to expand your reach.
Correct.
By taking these cases
Correct.
that can help benefit.
Right. Like
everybody.
if it's a case where the SEC is trying to push the law in a pro-SEC direction that we think is harmful, somebody needs to fight back against that. So you do that by representing someone in a case where the SEC is going too far. The SEC is overreaching. So we formed ICANN to fill that gap. No one was sort of paying attention to the fairness of the process, and the people who need to be able to do that are the people who can't afford counsel. So we're that counsel.
Wow. So like what happens to the advisor, right, who gets caught up in this mess, and there isn't an ICANN? Like, what does that road look like for them? Yeah,
it's ruinous. It's financially and professionally ruinous. To take one of I'll refer to him by first name, but we have a client named Eric, and he was working at a shop, low-level salesperson, selling a product. And had we not been there, and we're still not done, we're actively litigating this case right now, the SEC sued him, and he would have settled. He would have paid an enormous, or he would have had a judgment entered against him for an enormous, hundreds of thousands of dollars. This is a normal guy.
He's just like an employee.
Yes.
Of this enterprise.
Of the enterprise.
And the SEC sued him.
Sued the enterprise
and named him.
Sued the principals, and then sued a bunch of low-level people who were there just working. And this is a company that had hired legal counsel and compliance counsel. They believed they were operating compliantly with the law, and he certainly did. He's not management. He's just showing up to work.
He probably didn't have the resources to hire his own independent counsel or compliance.
No chance.
So he's relying on his company to provide him with guidance.
Right. And that seems like a reasonable thing to do. But at the end of the day, if we had not been there, he would have settled, because how's he going to fight? Right. He would have paid or had a judgment entered against him of every penny he made for every day that he worked at this place. So hundreds of thousands of dollars over like a 5-year period of time. Every penny he made, plus penalties. Plus, on top of that, the SEC is seeking to bar him from ever associating with anyone in the financial services industry forever. So,
my understanding is the product they were selling wasn't a security in the first place.
Right.
And so they were barring him from the industry he wasn't even associated with.
Yes.
As a result, I don't really know you want to get into detail, but
no. So he was. So this is a little in the weeds, but he was selling something called securitized life settlements. So there's an open question for new products, particularly for those working in the alternative space. I mean, we just went through this with years of crypto.
Right?
Are these assets, life settlement policies, crypto, gold bars, whatever, are they securities? If yes, they are securities, then the SEC has jurisdiction and all sorts of regulatory things kick in.
Of course.
You got to register as a broker, whatever. If no, then those things don't kick in. So there was an appellate level court decision out of the Washington, D.C., so the SEC's home court, that looked at this instrument and said, these are not securities, in a case unrelated to my guy.
Okay.
So you would think we could all go about our business.
So they had precedent from...
A very good precedent from a very high court. Like, this is not just some judge out in Kansas, not to pick on Kansas, but
Right.
like, this is a real court, a real decision.
The D.C.
Right. And what the SEC is able to do and did do is to, okay, well, that's just the District of Columbia appellate court. My clients are out in California, so that's a different appellate court. That decision in DC is not binding out here. There's a different appellate court. So the SEC just embarked. They didn't like the answer that they got from that court. So they started litigating that issue all over the country in other courts until they could find a court that agreed with them. And that's what got our guys caught up in it. They took the position that this thing in California was a security, even though there was already a ruling that they had in their home appellate court. And
Wow.
that was the court decision that the counsel who gave the advice was relying on. I said, no, there's a court decision. This is not a security. So the SEC said, no, we think it is a security. And you're in California, so this court case doesn't help you. So, and this, again, we're a rank and file employee.
But the court case happened, that they were relying on, happened before the California court case that disagreed with it.
Yes. And it was the SEC. Like, it wasn't some other party, like a private litigation. It was the SEC.
Oh, the SEC brought it to California to win it. So that they, oh my gosh.
Right. No, it's infuriating.
So this is all the legal maneuvering that's happening right now within our government.
Who is going to enforce, who is going to make the SEC comply with decisions that are already out there? The SEC isn't going to do it. They're going to push the envelope in every way, in every case, on every issue. I know, because that was my job. That's what I did. Like, I want to win the case, so I'm going to make this argument. So anyway, Eric, the rank and file employee, he doesn't know any of this is going on. He just shows up to work. And then he gets hit by the dump truck.
Right.
He gets sued in federal court. And so your question was, well, what are like normal people? How do they, well, you hope you have insurance. You hope your employer will indemnify you for your legal expenses. And you hope that the SEC doesn't take unreasonable positions.
Wow,
it's tough. But so anyway, we're representing Eric, and
that's an active case.
Active case. We are seeking review by the Supreme Court on that issue.
Because you got two different jurisdictions.
Right. Yeah. So anyway, we would like to represent 100 Erics, and it's somebody's got to fight for these folks. And he didn't have funds. So
that's crazy.
Yeah.
So we were talking the other day. There was another case that was interesting.
Yeah.
That you brought up. You care to share that one?
Probably Joseph Collins.
Yes,
I think the one we were talking
I
about.
wasn't sure you wanted to mention the name.
Yeah. No, he's very public about this.
Okay.
All
right, Joe. Hope you're watching the Vault of Views.
Result. So Joseph, another person not accused of fraud. So Joseph was running a business called Punch TV, where the business was going to create streaming content for urban audiences.
Okay.
He was one of the first, I don't know, your audience probably is familiar with this, one of the first Reg A Plus offerings. So this came out of the Jobs Act. It's a way to raise money from accredited and unaccredited investors.
Right.
So he does that. He's not a lawyer, so he hires a lawyer, gives him advice on how to do it. You're supposed to have an accountant. He hires an accountant. So anyway, he goes out and he raises from his friends and family, community of people interested in this business. He raises $1 million. Fly speck of an offering, but good for him. He's able to do it. And then he's still raising money, and he realizes, oh shoot, the accountant was supposed to be a certified public accountant, and he just told me that, unbeknownst to me, he's not a CPA.
Oh geez.
So he says, well, technically that means our registration, our Reg A Plus filings were inaccurate, and we didn't qualify for the registration exemption. So what does he do? He reports himself to the SEC.
He's a good guy. Hey.
Technical error. We would like to fix it. We're trying to get a CPA who can do the things that we're supposed to do. And the SEC turned around and sued him in federal court. So they sued him, and they asked for him to write a check for every penny he raised in that offering, which by the time this lawsuit, 2.5 years of investigation, by the time the lawsuit comes around, he's actually trying to run the business. He doesn't have $1 million to write a check to the government. So he hired a lawyer. He fought for a while in federal court, and then he ran out of money. And he represented himself for several months. And the SEC piled on, filed motions. He's pro se. There's no lawyer. And the judge tried to help him out, said, you're going to have to get a lawyer or I'm going to rule on the stuff the SEC's asking me to rule on, and asking the court for an order requiring him to pay back all of the money he raised to the government.
Not even to the investors.
No, not to the investors, to the government. So we found out about his case, and it was our very first case. We represented him. It was at the very tail end of the case. So it was only so much we could fight about. But the judge, we got him. We called the SEC and said, we're representing him. We called Joseph, told him we're representing you for free. We opposed their attempt to make him pay back all the money. It was like $1 million to pay back $1 million. And the end result is we filed a brief. We had a hearing with the judge, and the judge awarded the SEC $0 of disgorgement. So it was a case where, and by the way, there were real good reasons why the SEC was not entitled to that. But the SEC's not going to bring that up. They're just going to, we want to win. We want the big dollar. We want the win.
So this is yet another case where Joseph won, but he lost.
Yes. Right? Yeah. He still, yes. He had already lost in a prior, before we got involved, on whether he broke the law, because as he admitted from the outset, his CPA wasn't a CPA. So yeah, he did break the law. He did an offering that wasn't registered. So we couldn't undo that. So we were able to stop the SEC from at least entering a judgment that would follow him around for the rest of his life.
But just being a normal human.
Yeah.
Right. Like, to me, it just seems unreasonable.
Yeah.
Like, this is somebody who's self-reported.
Right.
Right. He said, hey, you know what? No harm, no foul.
Right.
Right. I'm going to correct it.
Right.
Right. And then they just pile on because they can.
Yep. Right.
And then that just breaks down the ability for us to protect investors.
Exactly.
Because when you got financial advisors or entrepreneurs in this space, right, acting in a way where they can't trust the SEC.
Yeah.
Right. The SEC clearly doesn't trust them. We're all guilty until proven innocent in their eyes.
Yeah.
Right. It's just that's what, when I looked at all that, just from my perspective, it was like, I want to have a relationship with my regulator to where, we don't have to go sit at the bar and have a beer together.
Right.
But we should be able to have an open conversation about how we're doing things together to protect the investing public.
Right.
But having gone through many audits over my career, right? They come in, bull in a china shop.
Yep.
Right. We're going to find you doing something wrong. We're going to send you a 17-page deficiency letter at the end of it. We're going to make you feel really bad.
Yep.
Right. We're helping a lot of people, thousands of people across the country, and maybe more through other avenues. But we're doing a lot of good. But then they make you feel like crap.
Right.
Right. When the reality is many of it's just administrative. This was obviously that's a big deal. You don't hire a CPA when you're supposed to hire a CPA. You know, but no harm, no foul. Like, nobody was harmed.
Right. By the SEC's own admission, they did not allege any harm.
Yeah. So I mean, I'm a CPA, right? I mean, I would not be qualified to do that work.
Right.
But he could have hired me.
Yeah.
And the investors would have been worse off.
Check the box.
Right. So the box would have checked.
Yeah.
Right. So they always use this form over substance thing.
Yeah.
Let's just do form over substance more often, right? Like, what was the intent? Was the intent to defraud investors, or was the intent just to put out an offering according to this, and he made a mistake?
Right.
Let's have an open dialogue conversation about these things.
How do we fix it?
And that reminds me, and I had an opportunity to meet Commissioner Hester Peirce. Right.
Yep.
She's wonderful. I'm not kissing your ass.
She's on her way out anyway, so kissing her ass wouldn't do any good. So kiss away.
No, I'm scrolling through Twitter or whatever one night, and she actually tweets out, "Hey, I'm going to be in Orange County. If anybody wants to meet me, I've got time in my schedule."
Mm-hmm.
I'm like, what? This is a commissioner opening up her schedule to anybody on the internet? This is
Wild,
wild,
yeah.
right? So I'm like, hey, I'll take a shot in the dark. I sent her an email. It went to her staff. It might have been like midnight or 1 o'clock in the morning because I don't sleep and I work late and, just what entrepreneurs do, right? But I'm like, to hell with it. I'm
taking her up on it.
I'm just gonna see, maybe,
Yeah.
And so I had to write something very carefully,
Right.
Obviously, because at the time my dad's suing the SEC,
Yep.
right? But I really wanted to meet the commissioner. No real agenda. I just wanted to have an opportunity to meet her. I followed her online and everything. The next morning, I get a phone call from her staff person, who was awesome, ex-Marine out of Camp Pendleton. Really nice guy. I forget his name right now. But we scheduled a meeting, and I was the last meeting for her for the day. So she had a long day.
Yeah.
I think she spoke in the morning, and then she was meeting people. It was in the hotel lobby bar. We're both drinking ice water. So, and she just goes, just tell me your story.
Yeah.
And she was very open, and I gave her some of my perspectives on things.
Yeah.
And I wouldn't say she agreed with everything or whatever, but just being able to have the conversation, right, at that level was amazing, right? And so I guess my takeaway is I believe there's hope for this industry to come together for the betterment of investors.
Yeah.
Yes, there's always going to be a few bad apples that spoil the bunch kind of thing.
Right.
But let's not assume that the whole bunch is spoiled.
Yeah. Yeah.
Right. Because there's a lot of great financial advisors out there, and if you look at it, there's so much to know, and it's almost impossible for any one individual financial advisor to know all this regulatory stuff while understanding sequence of returns risk and dollar cost averaging and social security strategies and legacy planning and I mean all these things that really are important to help people. Let's layer on some administrative stuff, right? And then if you get it wrong, we're going to put you out of business.
Well, that's, I think, right. I got to pause to emphasize that last point. So what we're concerned with is, and again, we're called the Investor Choice Advocates Network. If you make every contact with the SEC life-ruining, financially ruinous, professionally ruinous, who wants to go into that profession? Or like Joseph Collins, who wants to try and start up a little company and do like friends and family community? Nobody is the answer. You have to be a fool to want to do that. And who suffers? Investors suffer. You're not going to get quality investment advisors. They're going to go do something else. They're going to go, start another kind of business or something and stay away. So I think you're exactly right that we're fighting to have a fair process because we should have a fair process, but also because if we have an unfair process, our capital markets, which are the best capital markets in the world, are going to suffer. People are just going to go do something else.
Yeah, and that could cost jobs and everything else, right?
Exactly. Yeah.
Super thankful for you to be here, Nick. Before we wrap up, it would behoove me not to talk about my dad right now, but it's not really about him. So I learned about this concept along the way of the administrative state, right? And I didn't really understand it. I learned in school, through civics class, how a bill is made and how laws come to be, right? And then I learned that there's this administrative class of non-elected officials throughout our government that have twisted the rules a little bit over time that creates an environment where these rules set precedent that end up effectively becoming law without it actually going through the regular channels. Right. And so there's this thing called the administrative state out there. And in a way, that's kind of what happened to my father.
Not in a way. Law students study your dad's case because of that, what you just described, how the administrative state operates. It's I mean, how much time do we have? But it's infuriating.
We got a few more minutes to go through. I'm happy we have you around to be as infuriated, if not more infuriated than my family.
Yeah.
But yeah, I mean, ultimately at the end of the day, in a nutshell, just trying to dumb it down for the audience. They're very sophisticated, but it was the SEC bringing a case in front of their own SEC administrative law judge, of which this administrative law judge, no one knew who hired him. He was not accountable to anybody. He's part of the executive branch, which means you should have a direct or indirect line ultimately to the president, and that's how accountability is held.
Mm-hmm.
If you step out of line, you're going to get fired.
Mm-hmm.
If you don't get fired by your boss, someone's going to fire your boss because he didn't do the right job.
Right.
And which then ultimately created an environment that enabled, in my opinion, this one administrative law judge to rule, I think it was 50 or 51 cases in a row, 51-0.
Sounds right.
In favor of the SEC.
Yep.
Now, I mentioned form over substance a few times. I'm sorry, like if you're batting 1,000,
yeah,
right? Someone's got to take a step back and go, is
that
something wrong? That can't possibly
be right.
You're telling me this guy is doing it all by the book,
Right.
and they're just bringing the best cases and they're
Right.
slam dunk cases.
Right.
Nobody even batted an eyelash at a guy who's batting 1,000.
Right.
And I kind of remember it was my dad's attorneys at the time, after a phone call that they had with the Division of Enforcement about almost how they were celebrating the fact that this law judge was appointed to be the judge on their case.
We got the right.
And then they came back and said, well, we have a problem. We got so-and-so. I don't want to throw, I probably should throw his name out, but I'm not going to. I'm not that kind of person. But they were celebrating. They were spiking the ball in the end zone before we even had the hearing.
Right.
And my dad's legal team was like, we're stacked up against it.
Right.
So anyway, so that's this administrative state thing that I learned about.
Yeah.
Tell us a little more, Nick.
So the SEC, like other federal agencies, has the ability to create rules. So they're a little bit like you're like how do you make a bill?
Yeah.
So the SEC can create rules that are law that Congress never sees, the president never sees. So they create rules. They also have the enforcement division. They prosecute violations or alleged violations of those rules. So they are the legislative branch. They're the executive prosecuting branch. And then, as you found out with your dad,
the judicial branch.
an SEC employee is the judge. I mean, so they are literally the judge, the jury, the prosecution, the legislative branch. It's all the branches rolled up into one. And that's not fair. But it is the system that has existed for a long time. And I remember there was a time when Congress passed a statute called Dodd-Frank, expanding the SEC's ability to use. They used to be able to use this for a very narrow set of cases. And the SEC, there was a period of time, 2010, 2011, where they had lost 3 insider trading cases in federal court in a row. So a federal court judge appointed by the president with the consent of the Senate, lifetime tenure. They don't need to worry about political things. They don't always rule for the SEC, federal court judges, unlike your administrative law judge. So they lost 3 in a row, and
one of those was Mark Cuban's case.
It was Mark Cuban. They were
which that was all over the news. I'm sure they didn't feel real hot about that.
No, it was Mark Cuban, Nelson Obus, and then a man in Orange County who we've represented on something. Manoush Muschietti had an insider trading case that he won also. So 3 different juries, 3 federal courts. SEC loses in a row. And this is happening right about the same time Congress is enabling the SEC to use their administrative law judges more broadly, like in your dad's case. So the SEC's directive enforcement said, you know what? We just have to threaten the use of our administrative process and people settle. He was happy about that. That makes his job easier. None of us should be happy about that.
Right.
Yeah, that's terrible that the process is so unfair that they just threaten the use of it and people settle. And, Mark Cuban spent something like $14 million litigating and going to trial and winning in front of the jury trial. And afterwards he said, I'm fortunate to have the money to fight this, but most people don't. And then, so for those who don't know, your dad fought this unfair process and went all the way to the Supreme Court. And the Supreme Court, on the issue that he was arguing about, the Supreme Court sided with him and said these administrative law judges are unconstitutional. And thank goodness he did. Like, most people won't do that. Who's going to spend the time and energy to do that? And so because he was willing to do that, we all benefit. The process got just a little bit fairer there's a lot more work to be done. But
there's still more work, right? And
Yeah.
Obviously, I mean, my father, man of integrity. I wouldn't have done it. I advised him to settle.
Yeah, I mean,
and he's like, no, I want to have my day in court.
Yep.
He didn't realize it really wasn't a court.
Right.
But and then he was already all in. And
Yeah.
in a way, maybe they thought that he would settle by putting this law judge on this case.
Yeah.
Little did they know, tough Italian guy from South Philly.
It's not in his makeup to give up.
It certainly is not. He's still not giving up today.
We're fighting today.
We're still fighting today.
Yeah.
Let's go through a quick journey. So
Yeah.
so it was Lucia versus SEC.
Right.
Administrative law judges are unconstitutional.
Right. So says the Supreme Court.
Supreme Court.
Right.
7-2. Right. And then was it Jarsky?
Jarkissi, right?
Jarkissi.
Right.
Right.
George Jarkissi, man from Texas, gets put through the same unfair administrative procedure process. He says, wait a minute, I think the Constitution says something about a jury. We have a jury right? And I can tell you as a practitioner in the area, nobody thought you had a jury right in SEC proceedings. Like, it was just laughable. He, like your dad, had the fortitude to go all the way to the Supreme Court. Supreme Court says, yeah, in fact, if the SEC is suing you for fraud or fraud-like things, and they're looking for a penalty, you're absolutely entitled to a jury under the Seventh Amendment of the Constitution. So yes, so thank you, Mr. Jarkissi, for fighting for that as well.
Great.
And then just to round out the trio, and we're not done fighting, but these are cases, Supreme Court cases. Michelle Cochran, also from Texas. She was a CPA doing auditing. They tried to put her through the unconstitutional administrative justice system. And she went to federal court and said, hey, there are all kinds of constitutional problems here. And the federal court judge said, and I've read the transcript, very sympathetic, ma'am, I am so sorry. It does look like an unfair process. So says the federal judge, but my hands are tied. I have no jurisdiction. You have to go all the way through the administrative process, lose to the ALJ, appeal to the SEC, the ALJ's employer, lose there, and then maybe you get your day in court, not this court, but some other court. And she said, that's not fair. People should have access to federal court when they're saying that an administrative process is unconstitutional. You can't ask the SEC to declare itself unconstitutional. Right. That's ludicrous. So anyway, she appealed. She went to the Supreme Court. The Supreme Court ruled against the SEC in her favor, saying if ordinary citizens say that the SEC's process is unconstitutional, yes, you have access to federal court. But it took the Supreme Court to say that. Like, that's how stacked the whole process has been.
Yeah, I mean, and you went over that kind of quick, but it was basically you got to go through a process, lose,
yes,
then appeal
internally,
right, to
the commission,
lose again, right, and then you appeal
to an appellate court. You never get to a jury, but you can appeal it to the federal court, to an appellate court, and by then all of the facts have been decided against you. Like the ALJ let in all this sort of evidence that would never have come in a federal court. The rules were against you, but you're kind of stuck. That's the record. And then you're asking an appellate court to answer a constitutional question after all that's happened, after 5-10 years of this process. So that's if Michelle Cochran had not fought all the way to the Supreme Court, you'd have to do that. You'd have to go through that process.
So now, before the original hearing even happens, she can petition.
Go straight to federal court. You can go to an actual, what we call Article 3 federal court judge. If you've got a constitutional claim, you don't have to go through an unconstitutional process to make that argument. And so it's people like your dad, George Jarkissi, Michelle Cochran. These are all like ordinary people. They're not, Wolf of Wall Street types doing their job. And they had the fortitude and they had the legal counsel to push it all the way to the Supreme Court. And at the end of the day, the process is a little bit fairer. And so I thank each of them for that.
Yeah, great Americans, all three of them. Obviously, I'm biased for one of them. I've met Michelle years ago. Fantastic woman. Another great American. And lastly, there's this gag order thing.
Yes.
You mentioned that you're working on some stuff for my dad.
Right.
What was the gag rule and what recently happened? This is actually kind of somewhat interesting.
Well, I guess it's a good thing. But anyway, so I mentioned the SEC can create its own rules, its own law. So back 30, 40 years ago, the SEC created a rule that said, if you settle with the SEC, you may not speak badly about the SEC's case against you. So it's called a neither admit nor deny settlement. So everyone who settles with the SEC must agree to be gagged and not say anything derogatory about the SEC's case. And the way this comes up is lots and lots and lots of people settle with the SEC because it's too expensive to fight, as we've just talked about.
Right.
They would like to say that. They would like to say, I settled with the SEC yesterday.
Yeah.
Today, I'm telling you I settled because it was too expensive to fight. My side of the story is, well, you can't do that.
But they couldn't even say, I just made an economic decision.
No, you can't. No,
you can't even say that without
right.
even saying, here's my side of the story.
That's right. You would violate the gag rule, which is a rule the SEC created for itself.
And if you violate it, then what happens?
Well, the
They
SEC
just
would
reopen
undo
the
the
case.
settlement. Your case would become active again, and now you'd be in violation of a rule, the gag rule,
Yeah, okay.
and you'd be back in the soup. You'd be litigating it, and with more fury. So
Yeah.
So this thing, this gag rule sounds like a violation of the First Amendment, and there have been prior challenges. There was a challenge about 4 years ago, tried to get the Supreme Court to review it. We submitted an amicus brief on our own behalf and on behalf of Mark Cuban and Elon Musk. These are people who, don't want to be gagged. The Supreme Court 4 years ago declined to review it. Then there's a case now involving, we're not representing these folks, but I think involving your dad, involving the named plaintiff is Tom Powell, who sits on our advisory board. Again, challenging the First Amendment restrictions. ICANN submitted an amicus brief, a friend of the court brief, telling the Supreme Court, making this point. The First Amendment thing, that's real, like people should be free to speak. Good argument. Our argument was a little different. We said, the SEC prosecutes people for not being transparent with the marketplace. So they tell everybody to be transparent, except when it comes to their own lawsuits. And if there's anything bad to say about their complaint, they don't want transparency. And so we made the argument that as market participants who are, we want information, we are entitled to hear the other side of the story, and it's bad for markets. And it's contrary to the SEC's mission to gag people. We want information. So anyway, we submitted that brief. That case is still pending, but before the Supreme Court had a chance to rule on whether to review it, the SEC rescinded the rule, freeing people who were bound by these gag orders to speak freely about their cases. So that's good, but it can be reversed.
So it's interesting that after all these years, they just rescinded it. Is it just because we have a friendly SEC?
Well, I think that's part of it. I do think that the three commissioners currently in place, Paul Atkins, the person you met, Hester Peirce, and Mark Ueda, I do think they are not fans of the gag rule. So I think that's part of it. But the other part, obviously, the Supreme Court, the potential that the Supreme Court could rule on it, I think added some extra. I mean, it's not a coincidence that they rescinded it while this case is pending.
Yeah.
So the people who are litigating that case say the Supreme Court should still rule on it. The next commission could just create the rule all over again.
So it goes to the Supreme Court and they rule, then it's now permanent. Right now, it's just an administrative
There's
thing.
no
they just
finding.
decided, hey, we're not going to hold you to it anymore.
Right. So I think it's frustrating if you wanted the Supreme Court to rule on this important First Amendment issue. It's a little frustrating that they rescinded it now. But ultimately, it's good they rescinded it. But it'd be nice to have a Supreme Court ruling too.
Well, Nick, I mean, I can talk to you about this stuff all day.
Yeah, likewise.
Right? I mean, but who out there should reach out and if they want to talk to you? Like, who are you looking for? How do they support you?
Yep. Well, so thanks first of all for the platform and the conversation. This is great. I could talk about this all day too.
We're going to go talk about it a little bit more.
We're going to do a little bit more, and I'm talking about it tomorrow. So anyway, we are a 501c3. We're very public, easy to reach. We're at icanlaw.org. That's our website. And our donor base is made up of people who have either been put through the ringer by the SEC, and you come out the other end of that and you say, that's a terrible process. Something needs to change. Or people who could potentially be put through the ringer by the SEC and recognize the value of having someone watching and fighting back where it's appropriate. So if that describes any of your audience members, we would love to be in touch and love to have their support.
Awesome. Well, you're doing great work.
Thank you.
You are a great American here.
Well,
and
doing what we can.
Yeah. Thank you for leaving the the ivory tower out there in the big law firm, making all the big bucks, and coming over here to help us little guys, our financial advisors. And so thank you so much, Nick, for being on Vaulted Views.
Thank you. Thank you very much.
And so financial advisors and friends, let me just leave you guys with this. The low view on the SEC is to keep your head down and hope it never comes to you. To treat the whole thing as somebody else's nightmare, right up until the day it becomes your nightmare. To find out how the machine actually works only after you're already inside it. But the vaulted view is to understand the terrain before you ever set foot on it. To know that the deck can get stacked against any of us at any time. That most of these fights happen in the dark, and that the only reason the next person gets a fair shot is because somebody chose to fight the obscure, expensive, and precedent-setting battles today. And that's exactly what Nick and ICANN are doing. And that's the elevated way to think about your own protection, not as fear, but as awareness. ICANN is a nonprofit, and they do this work for free for people who need it. So if anything that Nick said today struck a nerve, please reach out to him and his team at icannlaw.org and support the mission. For show notes and links to today's conversation, please head over to my website, rayluciajr.com. And if you're an advisor who wants to grow with intention, build with intelligence, and serve at the highest level, come join us inside the Quotient Advisor community. And if this episode resonated, please share with another advisor who needs to hear it. And Nick, thanks again for being here on Vaulted Views. And hey guys, remember, stay elevated, stay strategic, and stay vaulted. I'll see you on the next episode.